to make representations to the court in support of the scales of costs which are asked the council. I'll be very brief. Your Lordship will have noted the voluminous nature of this matter. It is complex. It took many, many months to get our heads around the facts, to locate missing documents, and to ultimately come up with this application which is before you. So we say those scale of costs are warranted, and we move for the relief in terms of the notice of motion. My Lord, unless there's anything in specific that your Lordship wishes to.
You've dealt with the defences raised, Mr. Masuku's heads.
Yes. Yes.
Broadly speaking, saying you say there's no merit to any of those defences. You want to address any of them specifically
No, my
now,
Lord.
or to reply if there's something?
No, my Lord. We don't. Realistically, we do not see why we would be called upon or asked, or that it would be necessary for us to delve into the legal defences. We have done so in our main heads of argument. We've dealt with each and every one, and your Lordship should take cognizance of what we say. But for me here today to speak about a defence that Mr. Zuma didn't know who was being appointed and who was being paid, and allegations such as the state must claim from the deceased estate of Advocate Kemp J. Kemp. What am I supposed to address the court on such allegations?
As far as those issues are concerned,
Yes, my Lord.
if there's something that arises,
Yes, my Lord. The important thing is that we're not being unsympathetic to Mr. Zuma. But what we mustn't lose sight of is, and I don't want to start a debate on an emotional level, but this country has suffered much. Its history is not attractive. But what it culminated in is...
Perhaps we could put it this way, that insofar as ability to pay is concerned, that's not something that this court would necessarily have to deal with.
Well,
debtors, the ability of the debtor to pay is really something quite separate and distinct from
no,
the liability.
No, in law, the only cases where the court can intervene when a debtor says, I'm not able to meet my legal obligations, my payment obligations, as your Lordship very well knows, is in terms of Rule 46, when there's a foreclosure on a house. But that's of no moment. This is not a similar case. But what I say is that the history of this country eventually led to this document that we have to respect. We live in a constitutional democracy, and we cannot flout the law. So I repeat again, it's not as if we're unsympathetic to Mr. Zuma, but everyone around him told him that he was entitled to legal funding. And that ultimately culminated in a decision by a full court and endorsed by the Supreme Court of Appeal on the basis of vindication of the rule of law. So whatever Mr. Zuma tells this court today is of no moment. What is more important than the rule of law? There's not been any challenge to the full court's decision. Well, you can call it a full challenge insofar as the SCA is concerned, but the SCA merely dealt with an appeal on a very narrow basis that said specifically that the full court's decision shall stand and that society can rely on that judgment. So in the absence of any challenge, which by any stretch of the imagination could not have happened, what would be the purpose of us dealing with the defences today? Where will it take us? The doctrine of clean hands or unclean hands or lashes, for example, as Mr. Zuma expresses, the reckless, negligent conduct of the state attorney, the presidency, the Minister of Justice, and whoever else. Of what relevance is that, my lord? Everyone was wrong. And who will ever know the truth, my lord?
Mr. Bakili, shouldn't I hear from Mr. Masuku on those aspects? Whether they're of any moment or not, whether they carry the day, is something that ultimately I have to decide.
Yes, Mr. Masuku is quite entitled to, but I'm saying for me to address your lordship and say, this is what he says and this is our answer, we simply submit to you respectfully that it is of no moment, given the law, the facts, and the decisions by the two courts. So I'm not saying Mr. Masuku must not make his submissions. He will do so, obviously. But there's no answer to the applicant's claim. Thank you, my lord.
Thank you. Mr. Masuku, the issue of Mr. Rosenberg's counter-application, I don't know if you discussed it between yourselves. Would it not, from a timing perspective, be perhaps easier if I hear from Mr. Rosenberg and then you can answer to both Mr. Bakumides and Mr. Rosenberg?
Yes,
then once you've done, I'll have replies from both of them.
That's okay.
Thank you, Mr.
Thank you, my lord. My lord, perhaps the best place to start is to cast back to what the DA and its fellow applicant in the original High Court application sought, and that is set out in pages, or at pages 11 and 12 of the SCA's judgment, 001-110 of your lordship's record. And at paragraph 16, the SCA sets out the terms of the notice of motion of the DA, and paragraph 4 of the notice of motion contained the following prayer: Mr. Zuma is directed to repay to the National Treasury any and all such amounts that the state has paid towards Mr. Zuma's personal costs as a result of the decisions referred to in paragraphs 2 and 3 above. And in paragraph 17, the EFF relief is set out, and in paragraph 3 of the latter's notice of motion, one sees the following: a prayer that within 6 months Mr. Zuma and Hully Inc., liable jointly and severally, shall repay amounts of the impugned payments plus interest at the prescribed rate calculated from the date of each payment. So the relief, of course, from the get-go was not only for the setting aside of the impugned decisions to fund the legal costs, but it was pertinently for repayment. And that was an issue which was dealt with in a number of respects before the High Court. And while we are at the SCA's judgment at paragraph 19, the SCA says, on appeal, which is opposed by the DA and the EFF. It's contended on behalf of Mr. Zuma and that the High Court was wrong to hold. And paragraph C is a contention and a ground of appeal that it was just and equitable to require Mr. Zuma to repay the money. So the question of repayment was not only contested in the High Court, it was a ground of appeal which the SCA had to deal with. And if one then turns back to the High Court order, which is at 011 94, paragraph 81 of your Lordship's papers, the court there concluded at page 01195 in the concluding section of paragraph 81 as follows: simply declaring the agreements and the decisions to appoint private legal representatives and to pay Mr. Zuma's private legal costs unlawful without ordering repayment would not achieve the remedial objects inherent in the relief which a court should grant in the vindication of the rule of law. So that was the prelude or the basis upon which the court then proceeded to grant the relief which is set out in paragraph 88, and in particular paragraph 88D. We have set out the terms of paragraph 88D in paragraph 5 of our heads of argument. Our heads of argument are at 011-3 of your Lordship's papers. And we've referred to that as the repayment order. And we make the point that Mr. Zuma now seeks, quite impermissibly, to contest the repayment order. Well, it's no longer open to Mr. Zuma to contest the liability for repayment. He was at large and did contest that both in the High Court and in the SCA. That has now been finally determined, and the heads of argument that have been presented by on behalf of Mr. Zuma to this court consist entirely of an attempt to relitigate the repayment order. Now, your Lordship will have seen that the DA doesn't oppose the relief sought by the applicant, but it seeks certain additional orders. And it does so in order to advance the effectiveness of the repayment order. We have set out in paragraph 14 of our heads the well-established duty of the court to impose effective repayment, or to impose effective relief, and in doing so to craft effective remedies. There's a duty, in short, on the courts to ensure effective relief, and a corresponding discretion that the courts enjoy to fashion appropriate remedies. And the court, the first instance, the High Court, recognized the need to exercise a monitoring function in its order. As part of its discretion to fashion an appropriate remedy, it crafted a monitoring supervisory order for the court to continue to participate. Nobody objected at the time to that order, it wasn't appealed, it wasn't a ground of appeal that either Mr. Zuma or the applicants sought to advance. And of course, the applicants before your lordship today do not oppose the DA's application effectively for further supervision, which is really just building upon the High Court's order that supervision was appropriate given the circumstances of this case. And we would submit, quite rightly and appropriately, the applicants don't oppose the supervision order, which is a supervision order, we will demonstrate to your lordship, of particularly narrow compass, and it is only of application to the state attorney, and it operates for a very limited purpose and in a limited field. The background to the DA seeking a continuation of the supervisory monitoring order that the High Court fashioned is set out in paragraph 17 of our heads of argument. Your lordship will be aware of the fact that pursuant to the SCA's decision, a letter of demand was served on Mr. Zuma on the 14th of September on the 1st of October 2021, and thereafter the State Attorney failed to take any measures to recover payment from Mr. Zuma until the 8th of January 2024, when it filed its notice of motion. And this is, of course, notwithstanding the fact that the court directed the State Attorney to take the recovery measures forthwith, to report on progress within 3 months of the date of its order. We know that the State Attorney reported to the court in July 2021, and it reported that recovery steps would be taken to commence within a month from the date of delivery of this report. And in the counter application, the DA has drawn specific attention to the State Attorney's failure to account for its inaction for over 27 months from the service of its demand on Mr. Zuma in October 2021 and its institution of the application in 2024. No explanation has been given in reply, and counsel for the applicants has indicated that there is no explanation that he can give. That speaks volumes as to the need for the supervisory order that we have sought.
Mr. Rosenberg, how, beyond the filing of a report, would such an order be effective?
Well, we've set out the terms of what we submit is an appropriate, more effective supervisory
That's what you
order.
want them to do.
Yes.
But if they don't do it, well, the first thing is you say the court. Is it meant in the wider sense that it will simply be uploaded and vigilant parties will then monitor what's contained in the report, and in the event that they perceive a failure to comply with any provisions of the order, then take appropriate remedies, or that the court itself almost exercise a case management type oversight where the order is then comes to a specific judge who remains seized with the matter? Or
Yes.
is it the former or the latter that you had in mind?
It could be both, my lord. I will get to the exact terms of the supervisory order that we propose, but it caters for a situation where the parties can approach the court, and correspondingly the court itself can appropriately call the parties to explain or to report back further. And I'll get to that when we deal with the terms of the counter application or the notice of motion. Now, the principles of supervision, we set that out in paragraph 55 of our heads of argument. I'm not going to take your lordship there. Suffice it to say, in these circumstances, the purpose of the order sought is pragmatic, not punitive at all. And the DA submits that the public interest in this matter, and in particular an effective remedy for the recovery of the costs, cannot adequately be served on the basis of a one-off order. And that, of course, was recognized by the court of first instance. And a supervisory order such as this, to perhaps circle back to the point that your lordship made, has been recognized as amounting to a judicial commitment to work together with the parties to resolve a particular constitutional infringement. So really, that is, in our submission, an appropriate summary of the nature and purpose of the order in question. And Sabir, I can just get your lordship's reference to Sabir, which is a decision of the Constitutional Court. The full reference is Sabir versus the Director of Public Prosecutions, Constitutional Court case 45/04, dated the 25th of May 2005. That case is referenced in the article which we've referred to in our heads of argument by Roach and Budlander, mandatory relief and supervisory jurisdiction, when is it appropriate and equitable? And at page 332 of that article, there is a reference to the Sabir case, and at page 333, the authors summarize when a structural interdict, and that would include an order which, in addition to a mandamus, provides for elements of supervision and monitoring. When supervision and monitoring will be considered to be appropriate, one such circumstance, according to Sabir, is not only a failure to heed declaratory orders or other relief, but relevant to this case, where it is clear that it is not only an anticipated complete failure to comply with an order which may trigger a structural interdict, a supervisory order will also be appropriate where the facts indicate that it is inadvisable for the court to assume that the order will be carried out promptly. And there's every indication here that it is, given the passage of time and the failure to provide any explanation, that it is reasonable for the court, it would certainly be inadvisable for the court to assume that the order will be carried out promptly and effectively. The orders that the DA seat address first the question of interest. I'll deal with that relatively briefly at this stage. That's addressed in at paragraph 20 and following of our heads of argument. we submit there that the common law position is well established, set out in cases like Crooks Brothers, and in particular also in the Thoroughbred Breeders Association case, which is referenced by Crooks Brothers. Your Lordship will see those references in paragraphs 20 and 21 of our heads of argument. And we submit that the common law position is uncontentious and clear. Mora interest is payable in respect of a debt which is liquidated and which is due and payable. Your Lordship may refer in particular to Thoroughbred Breeders Association, paragraphs 84 and 85, for that proposition. Allied to the common law position, we have the position set out in the Prescribed Rate of Interest Act. Counsel for the applicants has referenced paragraph 2A of the Prescribed Rate of Interest Act. Section 2A of the Prescribed Rate of Interest Act provides that interest is payable on every unliquidated debt as may be determined by a court of law or an arbitrator, and shall bear interest as contemplated in Section 1. So the principle that is set out in Section 2A is that in respect of, not only in respect of liquidated debts, but also in respect of unliquidated debts, which in the process of adjudication become liquidated and due and payable, interest becomes payable. So interest is payable, in short, on a liquidated amount or liquidated debt which is due. The principles with respect don't need to be debated any further. They are sufficiently well established. And the applicants initially were minded to apply to amend the notice of motion to include a prayer for costs. They didn't do so on a twofold basis. The first and most significant of which appeared to be that for some reason this was not regarded as a debt. With great respect, that contention is entirely unsustainable. The court ordered repayment. That is the obligation. That is a debt as a result of the order, or as a result of the repayment order. And with great respect, that's the end of the debate. One doesn't have to determine whether this debt originally can be categorized as arising in contract or delict or enrichment. It is irrelevant.
But you're only seeking interest from the date of
Demand.
demand.
Of course.
So the question of the nature of the interest, whether it's damages or becomes irrelevant.
Entirely irrelevant. This is a very simple proposition that for some reason has been made marginally more complex than it ought to be. This is a debt which is liquidated amount. Demand has been made, and on the uncontroversial principles of mora interest, interest at the prescribed rate runs from date of demand. And the
prevailing rate, whatever it may have been, at the time of that demand, or at the time when
at the time of the demand.
At the time of each of the demands.
Yes.
Or is it at the time when the liability to pay, the order of the full court was made?
No, it's at date of demand.
Liquidated.
It's at date of demand, because it wasn't liquidated at that. So it should run from the date of demand at the then prevailing rate in terms of the prescribed rate of interest.
The section you read out, unless I misheard, says if it's unliquidated
Yes,
as well.
yes,
So if the section provides for interest on unliquidated amounts and the liability is established by the order of the full court, I'm not talking about the actual amount of the interest,
Yes.
the calculation of the amount, but the determination of the rate,
yes,
because it's the prescribed rate.
yes,
So, and the prescribed rate changes, it goes up and it
of
goes
course.
down. So you say the determination of the prescribed rate, if interest is payable, will attach to the two demands and the particular prescribed rate on the date of each of those demands.
Yes,
So you'll keep you don't do a combined rate calculated on a straight line basis on the total amount. It would be two separate amounts which would run in parallel, either at the same rate but for different periods, or at different rates. Okay.
that's correct. The with regard to the,
When the time comes to collect, that's often a question that arises in
Yes.
terms of how the writ is to be formulated.
Yes.
If it's unclear, one could have a problem. Okay.
yes, it oughtn't to be unclear, but it oughtn't to be difficult to make it clear, and your lordship clearly appreciates that. And if it's clear that it's at the then prevailing rate,
Yes.
as at the date of demand, that should be uncontentious. It is correct that the High Court and the Supreme Court of Appeal didn't specifically mention interest, but again, that's not surprising. The repayment order recognized that the state attorney was still to complete a full accounting and quantify the amount. It also appreciated that, or it anticipated that accounting to determine the amount would take place, and that thereafter there would be further process to operationalize the repayment order.
The
And
interest is a consequence of the non-payment on demand.
That's correct.
It's not anything in consequence of the liquidation as such.
Yes, absolutely.
And that's just basic moral interest.
Yes, and that arises by operation of law. And a claim for payment of interest would ordinarily only follow once the debt was liquid and demand was made. So we submit that in those circumstances, really nothing can be made of the fact that the High Court and the Supreme Court of Appeal didn't specifically mention repayment of interest, interest rates and the like. And we submit that really is the end of the inquiry. Of course, the court would also consider whether the payment of interest is just and equitable, but that's subsidiary to the application of the actual principles. The fact that it's just and equitable is an explanation why the principles operate as they do. And we submit then that the additional prayer for the payment of interest as proposed in the notice of motion in the counter application is appropriate. The question as to when interest begins to run, we deal with that in paragraph 40 of our heads, and we don't submit that needs to be dealt with any further. I've debated that with your lordship. In paragraphs paragraphs 45 and following of our heads, we deal with the submission that it's appropriate that it's that this court should put the State Attorney to terms to take measures to attach and execute on Mr. Zuma's property within a specified date from the date of the court's order. The DA has proposed a period of 60 days. None of the applicants nor Mr. Zuma oppose that order as we understand it. And the DA also proposes that the order make specific provision for the attachment and execution of Mr. Zuma's salary benefits, if necessary, to recover the debt. And we say that that is a pragmatic remedy in the exercise of the court's powers under Section 171B of the Constitution.
Is it possible to just order the attachment of the entirety of the benefit without any regard to the personal circumstances of Mr. Zuma?
Yes, that is an attachment it is an asset which may be attached. It's not, of course, and we, depending on what submissions are made on behalf of Mr. Zuma, it's not a pension fund right in terms of Section 37A of the Pension Funds Act. Your Lordship will be aware from our submissions that it is a benefit which flows from Section 2 of the Remuneration of Public Office Bearers Act 20 of 1998. We've prepared a short note on that for your Lordship's assistance. Perhaps it can be appropriately handed up now, just explaining the relevant legislative provisions and explaining why this is not a pension fund benefit in the sense or within the definition of that term in the Pension Funds Act, and why Section 37A of the, I've got 2 copies of the Act doesn't find application.
But if one accepts that it's a monthly accrual that flows by virtue of the office that was held by Mr. Zuma.
Yes.
And it's a personal right that accrues to him, subject to benefits that may follow after his passing. But the question is this: how is Mr. Zuma going to live? He's elderly. He's in his 80s.
Yes.
If an order is granted that the entirety of his pension is to be taken or to be attached, the entirety of his benefits each month as it accrues is to be taken, is it appropriate for this court to make such an order? Isn't there a mechanism for determining what's necessary to live and what's available for payment to one's creditors if such an order is made?
My Lord, we fully appreciate that. And the submission is that in the ordinary course, this particular asset is an asset which may be attached, subject to which any rights Mr. Zuma may have to contest the attachment of that asset if and when that should occur. Your Lordship is probably correct. It may not be necessary for the court at this stage to consider that, and it's probably not necessary for the order in terms to include to specify that the attachment includes the right to attach that particular benefit or asset. In our submission as a matter of law, in due course, that asset is one which may be attached. But there may be, in the context of that attachment, an argument to be made along the lines that your Lordship has indicated, that although it's not a pension fund benefit as contemplated by Section 37A, in certain respects it's analogous, and it doesn't, although it doesn't enjoy the protection from attachment that Section 37A confers on pension fund benefits, it may be that a court would consider it appropriate to craft appropriate relief should that attachment, in fact, take place in due course. And certainly not something on reflection that your